Hello. Today we've got Dave Bennett, Dave Kalish here from Coates & Bennett. Dave Bennett has about 25 years experience in intellectual property law. He's focused on trial and appellate court levels. I've known him for many years. He's done a lot of presentations for us in the Engineering Entrepreneurs Program. David Kalish, he's got extensive experience in patent preparation, prosecution, freedom to practice, and clearance attainments from mechanical, electromechanical, and computer-related parts. He analyzes and communicates his business implications in patent law. Their talk is intellectual property strategy overview for these kind of technology companies. And with that, I'll give that to Dave.
Thank you, Dr. Walsh. And good morning to everybody here. My name is Dave Bennett, as Dr. Walsh said, and my partner here is David Kalish. We're both patent attorneys here in North Carolina. Actually, we have an office in Cary, North Carolina. Our firm's been here since about 1987. It's one of the more longer-standing firms. We're very excited about the opportunity to speak with Power America today, and like to thank Dr. Walsh for giving us the opportunity. We hope you'll find this informative and you'll learn something. And I hope afterwards perhaps we can have an opportunity to have a conversation to learn more about what you're doing with your research in Power America. So with that, I will get started. The presentation is sort of broken down into five segments. The first segment we've titled here, Why Worry About Patents? And we're just going to go over why people get patents, how people use patents, why they're important to business. The second topic will be patent basics, and David, my partner, David Kalish, will be giving that presentation. Then that will probably take up the bulk of the presentation. We're going to try to go, because that's more important to your industry. We'll try to go very briefly through copyrights and trademarks and trade secrets, just to make sure you're aware of these other forms of intellectual property as you get business. We try to make it easy. All our presentations are given by a guy named Dave, so we try to make things easy for everybody. So the first topic, why worry about patents? The business world over the last 100 years has been shifting from one where value is derived primarily from physical assets or tangible assets to one where the value is derived from innovation and intellectual property. Ideas and innovations are the primary assets of the largest companies today, and not land or resources. If you think about it today, for example, the three largest capitalized companies in the United States today are Apple, Google, and Microsoft. And you can compare that, for example, to maybe 1950, where the large or the turn of the century, the largest companies would have been, J.D. Rockefeller owning his oil fields, or the Vanderbilts with their railroad empire, or Carnegie Mellon with his steel empire. The world today is very, very different than the one that started the turn of the last century. As we said, we mentioned before, the primary value of most companies today is in their technology, not in physical assets. To protect your markets today, you have to be able to protect those assets, and that's what the function of intellectual property is, particularly with patents. A patent gives the owner an exclusive right to make, use, or sell the patented technology for some limited period of time. Right now, the period of a patent is 20 years from the date you file the application. A company that holds strong patents is going to be able to survive in a competitive market. If you don't have good, strong patents, the companies will be put out of business rather quickly. An example of how a strong patent portfolio can protect your business. Look at the case of Kodak Polaroid. How many people remember who Polaroid was? Yeah, there's a few here old enough, but this patent case, it ended in 1991. But back in the 60s and 70s and 80s, Polaroid was in the instant camera market. They had no competitors. They had so many patents, and their patents were so strong that they were the only maker of instant cameras in the entire market. And in 1976, Polaroid Polaroid tried to break into the instant camera market, and from about 1976 to about 1986, Kodak was selling instant cameras using Polaroid's technology. Well, Polaroid ended up filing a lawsuit. Yes? Polaroid.
Left the conference.
Oh, people coming in and out. Okay, I'm sorry. Polaroid filed a lawsuit about somewhere about in the 1980s. The lawsuit went on for about 8 years. It ended up with Polaroid getting a $999 million verdict in 1991 against Kodak. Not only did they get a verdict, but more importantly, they got an injunction that put Kodak out of the instant camera business. So that's one example of how people historically have used patents to protect their markets and to create barriers for other people to enter to the market. So in the instant camera market, Polaroid had a complete monopoly at the end of 1991. Of course, that monopoly wasn't worth much probably about 5 or 10 years later as we moved to digital photography. So that's one way people use patents to protect their businesses. It's where they're gonna make products and sell it and use their patents to protect their market. A modern trend is companies are acquiring patents for products that to protect products that they don't even make or sell. There's a trend in the technology industry for large companies to build up very, very large patent portfolios and to license out their technology to other people rather than to make products themselves. Some good examples of companies that do this. IBM does that, although they have products, but they have a large patent portfolio. Ericsson, which has a presence here locally, Qualcomm, they all have very large patent portfolios. Our firm works a lot with Ericsson. Last year they earned about $1.7 billion alone from licensing their patents out to other companies. And these were patents, for example, for cell phones. Ericsson doesn't make cell phones anymore, but they have a large patent portfolio in there. So you can, and that's something that you could consider, as you're developing your technology. You could start a company if you wanted to, for example, if you had patents on, let's say you had a patent on a variable frequency AC motor controller or controller for an AC motor drive. You could use that patent like Polaroid did to make motor controllers or AC motor drives and sell those yourself and protect your market. Or like Ericsson, you can license that technology out to other companies to sell those products. So that's just another way of leveraging your technology. You can use that if you're making product to protect your market. You can also license out your technology. You might think the examples I've given so far that patents are for very large companies. In fact, they're probably more important for small companies than they are for large companies. Small companies probably don't have diverse products. It's more important for them to protect their products with patents. If you're in the technology industry and you go to market with a product, there's nothing to prevent a larger competitor from copying your product. So it's unlikely that a small company could survive in a competitive market without patents protecting its core technology. I can give you examples. Back in the 1990s, Stack Electronics had some patents on some memory, and they ended up having to go to a lawsuit with Microsoft. They ended up with $120 million in a judgment, but without the patent, they would have been out of business. So, and you see those cases all the time. In 1980, that's roughly in the time frame when I started practicing. I started practicing a few years later. Only 100,000 utility patent applications were filed and 60,000 patents were issued. In 2005, that number jumped to 400,000 utility patents with 140,000 issued. And last year, 600,000 patent applications were filed and 300,000 patents were issued. So this trend shows that patents are becoming more and more important to companies. And I don't have current statistics, but I couldn't find current statistics, but in 1972, only 5% of patents were issued to small entities. In 1992, that number had jumped to 23%. I couldn't find a number that's current, but I would guess that it's in the order of 40 to 50% of the patents now are given to small companies, not big companies. So that's sort of an introduction to why you should be concerned about patents. I'll turn it over to David so he can talk a little bit about patents.
Okay, as Dave kind of touched on briefly, a patent is an exclusionary right. It gives you the right to exclude other people from making, using, or selling your idea. It doesn't give you the right to do any of that. So that's a really big distinction that a lot of people don't understand, don't catch. But keep that in mind. That's basically rule number one when it comes to patents. It allows you to exclude other people, not do it yourself. A patent grant lasts for a specific number of years, depending on what type of patent you've done. In return for that, what you have to do is you have to make a full disclosure of your idea. Basically, it has to be made to the patent office. Eventually, it becomes public. The concept behind it is society's better off when people publicly disclose their ideas as opposed to keeping them secret, and other people can't use them to their own use and go from there. So that conceptually is what the idea of a patent is for. There's basically three types of patents that are available. As Dave said, utility patents, 20 years from the day that it's filed. And that's probably the most common type that you're going to see. That's going to protect the functionality of a device. A design patent is going to cover the ornamental appearance of something. A classic example of a design patent is for furniture. You can't get a patent on a chair. I mean, the functionality of a chair has been known for eons. But if your chair looks a little bit different than what somebody else's does, then that's when you would protect it with a design patent. And design patents last 14 years from the date of issue. And then you can also get a plant patent. If you invent a specific plant or plant species, there's an ability to get that. And that lasts 20 years from the date of filing. When you go to prepare a patent application, basically there's certain parts to it. You have to fully disclose your invention. And a patent basically has a background section where you're explaining kind of what the problem is that's currently in existence and kind of what your invention is intended to address. You have a brief summary of what your idea is, and then you have a detailed description where you really get into a lot of detail about the technical features of your idea. Usually there's drawings that go along with that, and also within the detailed description there's going to be an explanation of how you use the device, or maybe how you make the device, depending on exactly what your invention is. One of the most important parts about it is it has to be enabling. So the legal definition of what that means is one of ordinary skill in the art who comes along later and reads your patent would understand how to make and use it. So you can't hold something back. You can't keep something out so that at some point in the future when somebody reads it, they really don't understand what you have. That's the requirement, to make that enabling disclosure, and that's what allows you to get your patent grant. The most important part of a patent application are the claims, and that's at the very end of your patent application, and that's going to define, basically it's kind of a combination of legal and technical language, exactly what your patent covers and what it doesn't cover. Anytime during the examination of your patents, if there's any litigation involving your patents, the only thing that's really going to get looked at, or the most important part that's going to get looked at, are the claims. That is where you define the scope of your protection. Everything else, your detailed description, your drawings, your summary, all of that is used in order to interpret the claims. So by far the claims are the most important part of anything. So if you look at a patent and you're evaluating somebody else's patent, look at the claims, because that's going to be the most important part. It can disclose whatever, but if it doesn't claim it, it doesn't cover it. And so anytime you look at what a patent covers, you look at a competitor, they have a patent on such and such, take a look at the claims and find out exactly what they're really directed to. Because that happens all the time. For example, someone may disclose an invention that has elements A, B, and C. You look at their claims, they're only really claiming A. It has nothing to do with B and C. So you can't go out and say, well, this patent covers A, B, and C. It doesn't. It only covers a subset of that. So keep that in mind. That's a really important part. And just from a formatting standpoint, there's independent claims and dependent claims. And an independent claim stands by itself, and it introduces the invention, and it tells you exactly what's in it. So for example, a circuit board comprising elements A, B, and C. That's going to be the broadest claim in the patent. That has the fewest number of elements. And so when we look to see how broad or how narrow a patent is, you always start with the independent claims. And then in addition, there's what they call dependent claims, which just add further features or further aspects to what you've already introduced in the independent claim. So the example would be if the circuit board includes an additional element of D, that would be an example of a dependent claim. Now you would infringe a patent if you were to make a device or product or method that includes all the elements of at least one of those claims. And so that's another reason why the claims are so important. The claims, like I said, define the scope of what your patent covers and what it doesn't cover. And importantly, from a notice standpoint, the claims are important because they're going to explain to the public exactly what that patent covers and what it doesn't cover, which is basically a fundamental concept of patent law. You have to be able to understand what the inventor determines to be his invention and what doesn't determine to be the invention, and that's all coming through the claims. You prepare a patent application. For purposes of this discussion, we'll just assume everything's in the United States. We can talk about foreign filing. We'll talk a little bit about that at the end, but for purposes of this discussion, we'll just keep it within the United States. So you prepare a patent application, you put together your detailed description, you put together your drawings, you put together your claims, you go ahead and file it with the patent office. That's your date of filing. As of that date, it becomes patent pending. So if you've ever seen patent pending on something, basically what that means is there's a patent application that's been filed on it, but the U.S. Patent Office hasn't determined yet whether the claimed invention is patentable or not. It just gives notice to other people that you have an application on it, but it doesn't give you any other rights. You have very few rights while you have patent pending on it. It's basically a scare tactic in a lot of instances, if you will. If you see a competitor come out with a product that you think would be infringing the patent that you have, while it's pending, you can write them a letter, say, hey, I just want to let you know we have a patent, it's pending. Once it issues, we're going to try to stop you, but you can't do anything else. So it's got a lot of bark, but it doesn't have a lot of bite to it. There's no rights in your invention until your patent actually grants as a patent. When you file your patent application at the U.S. Patent Office, it stays completely confidential for at least 18 months. So nobody has access to it. You put patent pending on it, but nobody can find it. No one has any idea what it is. After 18 months, normally, the patent application will publish. So if you've ever done any research and you found a patent publication, it'll start with a year. For example, it'd be 2016 / some number. That means it's a pending application. That means that's not, you don't know if that's a patent yet. It's just purely what the person filed. So you can't look at a publication and say, oh my gosh, this guy has claims directed to a circuit board that's incredibly broad, we can't make our product. That's just pending. The large majority of the applications are going to get rejected, and they're going to have to make amendments to those claims to narrow the scope. So keep in mind, when you see a year like that, that's a publication. And it'll say at the top, it'll say publication number. So that's just where it stands during prosecution. That's not the final patent yet. It could be, but chances are it won't be. You file your patent application, and right now the U.S. Patent Office is backed up quite a bit. It will probably take somewhere between 12 and 36 months before you get an examination report from an examiner. It just sits there. You have patent pending, but there's nothing you can do. It's just sitting. It's in an examiner's queue, and it's working through his queue until he ultimately gets at it. Right now, for electrical-related applications, you're probably looking at the higher end of that. Software at the higher end, so you're closer to 24, 36 months. Mechanical applications are probably a little bit shorter. You're probably looking closer to 12 to 18 months or something like that. So during that period of time, nothing you can do about it. It's just sitting there. But that's to be expected. You know, I get phone calls and talk to people all the time and say, I want to file a patent. You know, I should be able to get this thing in 6 months. It's like, there's no way you're going to get it in 6 months. So you got to be realistic about what it is. You're not going to be able to do anything. And remember, when this thing's pending, someone can steal it, they can look at it, they can do whatever they want. You can't touch them. So you got an exposure period out there for quite a period of time. That's a business decision that you or your company is going to have to make. When do we publicly disclose this thing? When do we go out and try to start selling it? When do we start putting it into our products? Because we know we publicly disclose it while it's pending. Someone sees it, they put it in the product, we can't stop them. Some people will wait until their patent grants before they ever disclose it, before they put it into a product, for this reason. Other people will say, no, we have a patent application pending, we'll mark it pending. I'll take a chance that someone's going to, if they steal it, it's going to take them long enough to get it into their product that by the time they finally get it out into the market, or they're getting some commercial use out of it, my patent will grant and I'll be able to stop them. And so that's a business decision as far as what people want to do. There's different strategies as far as what's good, what's bad, but keep that in mind, that it is a long period of time that patent applications are going to be pending. Once you do get an examination report, there's about a 98% chance you're going to get a rejection. That's just par for the course. That's expected. Don't get freaked out when you get this big, long examination report back and it makes it sound like there's no way in the world you're ever going to get a patent. That's what the patent office does. Their job is to go through and make sure it meets all the requirements for patentability, and they do a pretty good job of rejecting cases. Sometimes they're legitimate, sometimes they're not. But you got to go through it. So I always tell people, when you file this, it's going to get rejected. So don't lose it when you wait 3 years before you get an examination result. You finally get an examination and it's rejected. It's going to happen. So just expect it. The examination report is going to give basically an analysis of why they rejected it, and they've got to the examiner's got to clearly explain exactly what his reasoning was. And most rejections are based on prior art. Usually it's other patents that are in existence before you filed your patents. And there's basically two requirements you have to have. One's called novelty, which means you're the first one to come up with the idea. And the way to think about that is, once again, this all relates back to your claim. Say you claim element A, B, and C, and a device with A, B, and C. If the examiner goes out and does a search and finds a patent that has all of elements A, B, and C, then he's going to say, you haven't met novelty. You're basically trying to get a patent on the same thing that's already out there. The other requirement is obviousness. You can't be an obvious variation over something that already exists. And the way to think about that is the examiner goes out and finds one reference that has A and B, and he finds another reference that has C. And if basically they're close enough together, so legally if one of ordinary skill in the art would read those two references, they would understand that, hey, I can put this stuff together and make a device with A, B, and C. If that's what you're trying to get on your patent, I'm not going to let you have it. You haven't met the requirement for obviousness. Those are the two requirements that we see more than anything else. Obviousness in particular is pretty common. I mean, there's a very, very good chance you're going to get an obviousness rejection when you file your patent application. The Supreme Court case about 7 or 8 years ago on obviousness, and they made it much easier for an examiner to reject your patent application based on it being obvious. They really raised the bar from the standpoint of the applicant as far as what you have to show that you're not obvious. It made it much more difficult to get patents. Not that you can't get them, but it made it much more difficult than what it used to be. You get a rejection examination report back from the patent office, and basically what you need to do is you have to respond. What you try to do is you try to respond basically within 3 months of when you get the examination report. You can extend it all the way up to 6 months, but you have to pay additional fees in order to do that. And there's a couple different ways you can do it. One of them are to make arguments. So using my example, I claim A, B, and C. You can go back to the examiner and say, hey, listen, you cited this reference that you say has A, B, and C, but it really doesn't have C, and here's why. And I can explain it to them. My claims include C, you don't have that, I meet novelty, I meet obviousness, give me my patent. The other way to do it is you may have to make an amendment to your claim language. You may have to narrow it, you may have to better define exactly what you think your invention is. And so that would be an example. So yeah, I have A, B, and C, but I also have this element E out there. And the prior art that you found doesn't have E. And so I think my patent is now in a spot that it claims an invention that isn't shown in the prior art, so give me my patent. It's basically the two ways that you can argue for patentability. One of the big things is once you file your patent application, you become patent pending, you can't add any new material to it. So for example, if I say, oh, what makes us different is element F, but I've never disclosed element F in my patent application. I can't now add it to my claims to use that as a reason to distinguish over the prior art. You're not allowed to add any new matter after you file the patent application. So it's really important that when you do file your patent application, you have a complete disclosure and you don't forget anything about it. That happens all the time. People come back and say, oh, I forgot. Either during examination or a month after we file a patent application, they'll come back and say, hey, I forgot, we just figured something else new. Can we add an amendment, an addendum or something to the patent application? And it's like, nope, can't do it. There's ways you can address it, but you can't address it in this patent application. You're stuck. When you file that patent, you're out of it. And that comes into timing. When do you file a patent application? The way the U.S. system works now is whoever is the first to file is considered to be the owner of the subject matter in that patent application. So you want to file it as early as you can. The problem is if you file it too early and you're still developing it, you may leave out elements. So you got to, there's a tension there, and so you've got to figure out, okay, am I far enough along with my idea that I pretty much know what it is, I'm ready to file for it? Or is it, well, I'm still really working on this thing, it's still kind of in flux, I don't think we should really file for it yet, I think we should wait a little bit and then we'll file it. So you've got to consider that. What a lot of people do is you may file multiple patent applications. So I may file a first patent application now that has A, B, and C, because I know I got that. And then say 6 months from now, I come up with, D, E, and F. I file a second patent application that includes D, E, and F, probably in combination with A, B, and C. And so there's a lot of different ways that you can do that. But just understand that once you file your patent application, that patent application's set. You can't add anything new to it. So keep that in mind, because that's a really big thing, a very big point when it comes to patent applications and patent prosecution. You submit your response to the patent office, the examiner looks at it, he may say, yeah, you're right, I'm going to grant the patent. He may say, no, I don't agree with you, I'm going to continue to reject it. He may give you a new rejection. Hard to say. Usually patent applications probably go through at least 2 responses back and forth between the examiner and the applicant, as on average. I mean, we've had them that they go 10 responses back and forth. We've had some that get what they call a first action allowance. The claims are allowed as filed. Doesn't happen very often, but it happens. But usually it's a couple iterations back and forth between making arguments and or amendments, and you get it. There are times that the examiner just doesn't get it, or he just continues to reject it, and then what you can do is there's an appeal board that you can go to and basically appeal the rejection. It's an independent 3-person panel that is part of the patent office, but you get it away from the examiners. Sometimes examiners just get stuck. They will not budge, and they're saying, no, reject, reject, reject. You say, okay, I'm done dealing with you. I'm going over your head. I'm going to go to the board. And there's a process to do that. Good part is you get away from the examiner. Bad part is it's somewhat expensive. You're probably looking roughly, and this is a guess, $3,000 to $5,000 to do it. And the appeal process can take anywhere from a year to 3 or 4 years. Not only is the examination backed up, but the appeal process is really backed up. So once again, there's strategy as far as what you want to do and what you don't want to do. Can you fix the screen? It's kind of locked up. Meeting center application is unable to connect to the meeting. Yeah, someone's trying to do something.
I wouldn't say I'm the best on fixing it, but we'll try.
Connect.
Connected to the meeting. Okay.
I just go through this.
Yeah. Hold on. Keep talking and I'll.
Okay.
Sorry. It'll take a minute.
once you get your patent grant, basically you pay the issue fee and you get a patent. You basically, they're going to give you a patent number, they're going to give you a ribbon copy. From that point on, you start marketing your product as patented, all your advertisement, all your literature, things like that. At that point, if someone comes along and copies your idea, then you can take them to court, patent infringement, so forth and so on. Average costs for doing a patent application can really run all over the board, depending on the technology, the complexity, things along those lines. Yeah, one more forward.
Is that good?
Yep, perfect.
I'll
Yep, you got it.
check, make sure we're still.
Okay. As a rough estimate, the costs for preparing and filing the application, you're probably looking at $6,000 to $9,000, and this is a rough cost. It can really vary depending on how complicated it is. As a rough estimate, there's probably another $3,000 to $8,000 to deal with the patent office and to convince them what you have is patentable. That's all their correspondence back and forth with the patent office. So as a rough estimate, you know, say $9,000 to $17,000. That's a big swing. It can run all over the place, but roughly that's probably about what we're looking at. And then obviously, like we said before, a patent gives you the right to exclude others from making, using, and selling. It's the claimed invention. So you got to look at the claims. The claims are the most important part. So what you got to keep in mind, if I filed the application with A, B, and C, but during prosecution I had to add additional elements to it, D, E, and F, that's going to narrow the scope of my patent protection. That's the drawback to it. It makes it more difficult for someone to infringe my claim. Somebody infringes your patent if they make a device or a product or a method that includes all the elements of at least one of your claims. So for example, if I get a patent through and it has elements A, B, and C, somebody comes out with a device that has A, B, and C, they infringe my patent. If they come out with a device that has A, B, C, D, E, and F, they infringe my patent because they have A, B, and C. If they come out with a device that has only A and B, they don't infringe my patent. They've kept one element out. So in order to infringe, you have to have every single element of at least one of the claims. So that's the drawback, or that's how this whole system works, is you want to keep your claims as broad as possible, but you still have to get the patent allowed. And so that's what you're fighting with the examiner over. He's going to want you to add additional details, additional limitations for patentability, which is great, you get your patent, but if you add too many, you're never going to be able to enforce your patent because it's such an easy design around that your patent probably won't have any value to it. So that's really how the whole process works, and that's the importance of the whole process. Inventorship on a patent. Anyone who contributes to the concept of the claimed invention has to be listed as an inventor. And inventorship is a legal definition. You can't change inventorship. It's to the claimed invention. It's not what I wrote about in the detailed description. It's not what I put in the drawings. It's what I put into the claims. So if I disclose A, B, C, and D, but I really only claim A, B, and C, then whoever the people were or person was who did A, B, and C, because that's what I'm claiming as my invention, those are the inventors. The person who contributed D probably isn't going to be an inventor. But you can't say, well, I don't want this person to be an inventor. Can we cut him out? It's like, well, what did that person add? If he added the subject matter that we're claiming as the invention, he has to be listed as an inventor. If you don't list it, there's a chance your patent could be invalidated at some point if you ever get into litigation. The other thing about it is each inventor has an independent right to exploit the patent application unless there's some type of assignment or some type of agreement to the contrary. So you go out and invent something with somebody else. You're both inventors. There's no assignment. Once the patent grants, you both have the ability to do whatever you want with it. The other person can't stop you. And so we see that a lot too. One inventor will go this way, one inventor will go that way. There's nothing either one can do. They're basically independent to do whatever they want with it. So there's a distinction between inventorship and ownership. And so keep that in mind too. Ownership is the person who owns it. They can control what's going to happen to it. Inventorship means they're the ones that came up with the idea that's going to be in the claimed invention. So keep that in mind. The way the patent system works now, it changed about 3 years ago. Whoever files first is the inventor of the subject matter. It used to be whoever invented it first, regardless of when you filed it. So that's a big, big change. The U.S. changed about 3 years ago, and basically every other country in the world is a first-to-file system. So that's once again where you want to file it as soon as you can because it's first to file. But is your invention ready for filing? Is it ready? Do you have it? Do you have the concept there? Are you still working on it? So you got to keep that in mind. But first to file now is really, really important. There's a few statutory bars that can prevent you from getting your patent on your idea. The big one is public use. In the United States, you have 12 months when you first publicly disclose your idea in which to file for a patent. If you wait until after 12 months, you're going to be barred from getting a patent on it. So I go out, I give a talk about my idea, whatever it is. I got 12 months from that date to file for a patent application. If I don't, I'm done, I'm out. So I can't get it back. There is what's called an experimental use exception. So I come up with an idea, but I got to test it. I don't know if this thing works or not. I want to go out and test it out someplace. That isn't considered to be public use under certain circumstances, but that's a pretty narrow exception. You got to be really careful with is something experimental or not. As a general rule, consider anything that's any kind of disclosure that's outside any requirement for confidence as a public disclosure. So be really, really conservative with that. If you think it's public, it probably is. The other one is on sale. If you try to sell this thing, once it's ready for patenting, you got 12 months from when that happens. So those are two big ones. The United States gives you 12 months from both of those. So keep those in mind. Everything we talked about now is in the United States. Now you can also take your patent application, or you can take your invention, and you can file for protection basically in any other country in the world. And there's a lot of different ways to do that. One of the big distinctions between the United States and foreign countries is the United States gives you 12 months from when you publicly disclose or offer it for sale. Most foreign countries don't. You have to file a patent application somewhere before you publicly disclose it. If you don't, you're barred. So here's the example. I have an idea, and I think it's good. I'm a small startup. I think it might be a good idea, but I'm not positive. I don't have a lot of money. I'm going to go ahead and publicly disclose it. I'm going to see if I can sell this thing. I'm out in the market. I'm trying to sell it for 6 months. It starts to sell. I'm like, hey, this is cool. I'm going to go ahead and patent it. I file a patent application in the United States, no problem. I'm fine with it. I'm within my 12 months. I don't have any issue with it. The problem is I can't get a patent anywhere else in the world, the large majority of the world, because I publicly disclosed it before I filed for a patent. So when you have an idea and you want to figure out what you want to do with it, you've got to consider, do I want to get foreign protection or not? Because once the cat's out of the bag, it's out. You can't put it back in. So keep that in mind. There's no right or wrong answer, but your actions have absolute ramifications to what you want to do with it. So keep that in mind. That's really, really important. When you want to get foreign protection, the talk is basically coming here out of the United States. What most people do is they file it first in the United States, they take that application, and you can then use that same application within 12 months and file it in whatever country you want around the world. There's a lot of different ways to do that. There's pros and cons to each, but just understand that you can do that. If you file it within 12 months of when you first filed it in the United States, it's as if you filed it in those foreign countries on the same day you filed it in the United States. So I filed a patent application January 1st, 2015. December 31st, 2015, I file it in China. Because it's within 12 months, it's basically as if I would have filed it in January of 2015 in China. It's called, you can claim the priority from it. So that's the important thing. Keep in mind that you can file for foreign patent protection. There's a lot of different ways to do it. Keep in mind it's there. If it ever comes up, we can talk about the specifics, because there are a lot of options for doing it. Provisional patent applications. A provisional patent application is purely a placeholder. It's a filing. You can put patent pending on it. It meets the first to file requirement so that you're going to be considered to be the owner of the subject matter. Good thing about it is because there's no formatting requirements, you can submit anything. I've seen scribbled notes submitted as provisionals. I've seen thesis papers submitted as provisionals. The most important part is you got to make sure you make a full disclosure. Don't leave anything out of it. There's no formatting. You don't have to put drawings. You don't have to put claims. You don't have to put a background. You put whatever you want out of it. You basically just get it on file. First to file, and it also meets any limitations of 12 months within public use or offer for sale. So a lot of people go this way. Once you file your provisional, you then have 12 months in which to file a non-provisional, a regular utility application. If you file within 12 months, you can once again claim priority back to the original filing. Good thing about a provisional is initially they're less expensive to file usually because there's no formatting requirement. One of the downsides is the overall cost is going to be more. So I file my provisional, and within 12 months I file a non-provisional. The cost of those two filings is going to be more than just for the provisional itself. That's just some specifics. We won't go through that. Dave, if you want to talk about copyrights.
Sure.
Sure.
Okay. As we've indicated earlier, we think patents in the business you're in are going to be more important, and so we spend a little bit more time on patents. But just to give you the complete view of the intellectual property, we're going to go very, very quickly through the other forms of intellectual property, and those are copyright, trademark, and trade secrets. A copyright is just a form of legal protection, just like a patent is a form of legal protection. Where patents apply to new inventions, copyrights apply to authors, to works created by authors. And these are works would be things like books, sculptures, paintings, photography, architectural designs. For the most part, copyrights are probably not going to play a key role into the things that you do. If you're in business, if you have marketing materials, you might want to copyright the marketing materials, and just to keep competitors from copying your materials. But as far as protecting your core business, that's not going to be important unless you happen to be in a software business. One of the things people may not realize that a computer program is considered a copyrightable work. The Copyright Office considers the source code of a computer program to be a literary work, just like a book. So you can copyright the source code. Also, usually the visual elements in a computer program could be classified as works of visual arts. People protect the user interfaces, and there's a lot of copyright cases revolving around what they call the look and feel of the computer program. It's what the user sees and how the user interacts with the program. So if you're in the computer business, copyrights would be important. And now the question. There are five exclusive rights of copyright, and those rights are the right to make copies of the work. We call that the reproduction right. The right to make derivatives of the work, that is, to create other new works based on the original work. The right to sell or distribute copies of the work. The right to publicly perform the work, which would only be important for things if it's like choreography or maybe music. And the right to publicly display the work. And those are the five exclusive rights. Your copyright is infringed if anybody else exercises any one of those five rights without your permission. A topic that comes up frequently in copyright cases that we deal with is who owns the copyright. As a general rule, just like an inventor initially owns an invention unless he assigns that invention, the author of a work owns the copyright unless that copyright's been assigned. In both the case of patents and copyrights, assignments of rights to those have to be in writing. The trick here for copyrights is what's the meaning of the word author? The word author might not mean exactly what you think it means. For example, the word author might not mean the person who actually created the work. In the case of works for hire, for example, there are two types of work for hire. If you're an employee and you create the work within the scope of your employment, for example, let's say you're a computer programmer, you work at a software company. If you write software, in that case, the employer is considered the author. So if the work is created and the copyright would be owned by the employer, and in fact, on the copyright application, the employer would be listed as the author, not the employee. The same thing happens in the case of an independent contractor. For certain types of works, and this is a fairly limited category of works, a work prepared by an independent contractor for another hiring party would be owned by the hiring party, but that only applies to certain kinds of works, and also applies only if there's a written agreement before the work is created stating that that's going to be a work for hire. We have situations all the time where people make the mistake of assuming if I hire somebody to create a work for me, and that person agrees to verbally to give it to me. Once I've paid them for the work, then I own it. That's not true. So, for example, if you're in a small business and you went down the street to find a graphic artist to do a logo for your business, and you paid him $500 and he gave you your logo, you would have the right to use it. There was an implied license through that arrangement, but you wouldn't own it. The independent contractor, the graphic artist, would still own it. He's an independent contractor. If you didn't have agreement, and people make that mistake all the time. That's why I raised that issue. Another common misconception about copyrights is that the work's not protected until you actually register the copyright. In fact, copyrights come into existence the moment that the work is created. As soon as the trigger technically for copyright protection is when the work is fixed in a tangible medium of expression. So as soon as you write the words on the page, or as soon as you save the work in memory of a computer, the work is protected by copyright from that moment forward. You don't have to do anything other than create the work in order to get copyright protection. You can register copyrights, however, but it's not the registration that creates the right. It's the simple creation and fixation of the work in a tangible medium of expression. It's important, I think, however, for people to register their copyrights. First of all, registration of copyrights is relatively inexpensive. It's $55. And when you go to court, you can't go to court to enforce your copyright unless it's registered. So if you create a work, you fail to register it, and then somebody infringes, well, the first thing you have to do is go file an application to register it to get a registration, because you can't sue for infringement without a registration. That will just delay the process of stopping somebody from infringing. The second thing that's important is the remedies that are available for infringement will be impacted by whether the registration occurred before or after the infringement. There are two remedies, one called statutory damages. You can get statutory damages of up to $150,000 per infringement if the registration is made before the infringement occurs. If the registration is afterwards, you can't get statutory damages. And the other really, really big deal is there's fee shifting provisions in the Copyright Act. If somebody infringes your copyright, then you may be entitled to recover your attorney fees for that infringement, but only if the work is registered before the infringement. If you wait until after the infringement, you can't recover your attorney fees. The fee shifting provision doesn't apply in that case. And in some cases where there's little damages, it becomes economically unfeasible to bring a copyright case unless you have the possibility of getting an award for attorney fees. So it's very important. It's very cheap to register copyrights. It's $55, so I would strongly encourage people when they do that, when they create works, to make sure they register them. So that's an important point. Those are sort of the main points that we come across dealing with copyrights. I'm going to go very briefly here through trademarks. I think everybody intuitively knows what a trademark is. You encounter thousands of them every day. You walk down the aisle at a grocery store, and every product has a name on it or design. But a mark, and I'm going to use the word mark here, not trademark, and you'll see why on the next slide. But a mark is any kind of word, design, or slogan or symbol, or it could be anything else that you use that a manufacturer applies to his goods or provider uses to identify their services. I'll give a couple of examples here. Everybody recognizes the Nike swoosh symbol. In the case of John Deere, the trademark is actually the color green, not a particular design. McDonald's, you got the word McDonald's, but you also got the golden arches, so you got sort of a design. In the case of the sewing thread, the trademark in that case was actually a fragrance that they applied to the thread, not any. People have gotten trademarks on sound. The one you might recognize, have you ever seen the Intel inside? The commercial, the chime, the Intel inside? That's actually a registered trademark. Harley Davidson tried to register the sound of its motorcycle as a trademark, but one thing about registering trademarks is a trademark has to be non-functional. Harley Davidson failed on that, by the way, because the trademark office found that the sound of the motorcycle was a function of the design, the architectural design of the engine, and so they didn't get trademarks for the. So a trademark could be a lot of different things. Those are sort of non-conventional trademarks. For color, I put John Deere. Owen Corning has a trademark for the color pink for insulation. They're the only makers of pink insulation. Most insulation translation, as you probably know, is yellow. I used the word mark previously because technically, and we use the trademark term very loosely, but there are two kinds of marks. There's a trademark and a service mark. And a trademark is a mark that you actually apply to your product to identify that product. Like when you see like the Nike swoosh symbol. The swoosh symbol is on the shoe, actually on the shoe, or it might be on the packaging. A service, and that is used to identify the source of those goods. Well, not everybody makes goods. There are a lot of people that just provide services, and a good example would be H&R Block. They fill out your tax forms, and of course H&R Block it's kind of like a trademark, but we technically we call that a service mark because it's not applied to any good. It's just used in the advertising of your service. So trademarks technically are marks that are applied to goods or applied to the packaging. Service marks are marks that you use in your advertisement to advertise a service. So technically they're the same. All the rules apply the same. If you want to be technically correct, you just call them marks. We loosely call everything a trademark, and people tend to understand you anyways. But there is a technical distinction. Trademark examples, these are all famous marks. I will go through those real quick. Yeah, by the way, these are, I'm going to back up, trademarks. These are marks that you actually see applied to products, right? Right. And service marks, Walmart, you see the sign on the store. Now, they might also use that. They might private label goods and put the Walmart brand on a good too. So it could be used, Jiffy Lube, you see the sign out front. McDonald's, that's the word McDonald's is both a trademark and a service mark. Here it's used on a sign, that's a service mark. But, you know, when somebody wraps your hamburger in a wrapper that says McDonald's on it, that's a trademark use because it's on the wrapper. Exxon's more of a service mark. H&R Block, that's the example I gave you. One important thing to remember about trademarks, we categorize trademarks. Yes?
I didn't interrupt you. Ms. Dennis, I just have a question.
Sure.
If you're writing a paper or a book and you refer to, let's say, Legos.
Yeah.
And do you have to put the little symbol in the text if it's an academic writing and you're referring to a product? Or say they're writing about, or do they have to?
When we do, I don't know that there's any legal rule, and in academia they may have rules about that. Dr. Welch might know the answer better than I would. I usually do one of two things. I capitalize the entire thing to indicate that it's a mark, or sometimes I do put the statutory registration symbol, which is an R with a circle afterwards. But you might not know, but that's only for registered marks. You may not know if it's registered or not.
Right.
So, but you know, maybe just put a footnote and say such and such is a trademark of, you know, and put that down in a footnote. I mean, I think it's a good idea to acknowledge that. In the patent applications, technically the patent office says if you use a trademark in a patent application, you have to capitalize the entire word. So, did you have a question?
Is there any case of obvious things like the patent, about the patent, like the obvious shape of an apple or like those things?
Well, there's no obviousness. The issue for trademarks is it's something that you adopt. It could be anything. There's no obviousness requirement. There's no requirement like in copyrights it has to meet an originality requirement. It has to be original. In patents it has to be obvious. In trademarks, a trademark is anything that you adopt and you use. If you adopt a symbol, you don't have to create it. You don't have to create the symbol. You can adopt symbols created by somebody else. You can find symbols out that you use, and then as long as the only criteria for trademarks, and we'll get into that in a minute, is all you have to do is adopt it and use it. If you use it, put it on your product, you own it. That's all you have to do. We're going to talk about that in a minute, but that's a good question. So, spectrum of distinctiveness. This is sort of important for trademarks. We categorize trademarks in 4 categories. They're generic, descriptive, suggestive, arbitrary. What we call a generic mark is really not a mark at all. It's just a common name for a product. For example, the word refrigerator. If you're in the business of making refrigerators, you can't adopt the word refrigerator and try to stop everybody else from using it. You know, those are public domain. They're free for everybody to use. So they're not really marks at all. But people try to register words that are generic all the time. I've been involved in litigation for a long time over the use of the term L house for bars. We've had clients that have been sued many times for using the word L house, which is a generic term. We've won every time, but they keep suing us nevertheless. Descriptive marks are marks that are not common names for products, but they're words that you might use to describe a product. Since I used the word refrigerator a moment ago, think about if you were walking through a store and you saw the word frost-free on a refrigerator, what would you think that means? You would think that's a feature of the product, correct? not describing. You wouldn't think that's the brand, but if you were walking through a store and you saw Kenmore on it, what would you think? So Kenmore is what we call a distinctive mark. Frost-free is not a mark. It's a descriptive term, and the default rule is you don't get protection for descriptive terms, okay? You can protect them. We'll talk about that in a minute. The last two categories are suggestive marks and arbitrary marks. Suggestive marks are marks that people use that connote some desirable feature without being descriptive. I think since we're talking about refrigerators and everything, how about igloo? Igloo, the word like something like igloo for coolers. Igloo is something that's cold, and coolers keep things cold. So that we call those suggestive marks. The mark like chicken of the sea for tuna. Marks like that we call suggestive. I could give you an example for the word apple. If you sell apples that you eat, the word apple is generic. If I say apple pie, the word apple is descriptive in that sentence. If I say apple a day vitamins, which is a brand of vitamins, apple a day vitamins, that's suggestive, right? And then if I say Apple computers, that's a name that was just coined, or an arbitrary word picked to computers. Apple in that case would be arbitrary. So one word could be in any one of those categories depending on what you try to apply it to. Well, there's some examples of arbitrary marks. Arbitrary marks are either made-up words, or they're just words that you just arbitrarily select to apply to a product. Apple's a good example of that. Amazon is a good example of an arbitrary mark applied to a service, in this case the online sale of goods. Exxon, Kodak are really good examples of made-up words. Those words didn't exist. Verizon, Xerox, those are arbitrary marks. Example of suggestive marks, here's some more suggestive ones. Greyhound, that's really fast buses, right? Chicken of the Sea, Coppertone, Roach Motel for even the Mustang for cars. People, they're wild and fast, and that's what the manufacturer wanted. So those are suggestive marks. Descriptive marks. You can protect descriptive marks if, and I won't go into how, but we have this thing called secondary meaning. If you adopt a mark that's descriptive and you use it long enough and exclusively over, let's say, a very long time, then you can acquire what's called secondary meaning, and then you can protect it. Some marks, Windows for a window operating system, for a windowing system, that's descriptive. Best Buy, parking lot, Miller Lite for beer is descriptive. American Airlines, that's geographic terms are considered descriptive. But this shows that you can have descriptive marks. They can be protected. Whoops, I had that slide in there twice. Obtaining trademark rights. This goes back to the question you raised a moment ago. Since trademark rights are just symbols or words that we apply to products to use to identify our services, the way we acquire trademark rights at common law is simply to adopt it and use it in our business. So once you adopt it and use it in your business, assuming nobody else has used a similar mark, then you own it. And that's how you get ownership of marks. It's who was the first to adopt and use it. And trademark rights are kind of like copyrights. You don't have to register a trademark to get the right. If you use it, the law recognizes your right of ownership to that, just from the use of the mark. For arbitrary and suggestive marks, the ones we talked about, they're known as inherently distinctive. You get rights from the moment you start using it. For descriptive marks like Best Buy, it takes time to acquire secondary meaning, so you might not get rights when you initially start using, but maybe after 5 years. The trademark statute has a provision that says they can presume secondary meaning after 5 years use. So if your mark is descriptive, you might not be able to register it for 5 years, but after 5 years you probably could. And generic marks are never protected. The protection you get for trademarks is you get the right to prevent other people from using similar marks that are likely to cause confusion. That doesn't mean you get the right to stop people from using the mark entirely or using the word entirely, but only to prevent other people from using it in a manner that confuses people. And that's the test. We call it likelihood of confusion. It's when one mark is so similar to another that it's likely to lead to confusion of ordinarily reasonably prudent purchasers. When you get into deciding whether one mark's confusing with another. Those are a list of factors. You know, the important ones are the marks similar? Are they used on are they used on similar goods or services? We have this notion called strength of a mark, which is a really abstract thing. But some marks can be strong and get more protection, and some marks can be weak and get less protection. Whether or not you're in the same channels of trade, do you sell to the same customers? Those are the kind of things. Oops, there's something missing on that slide. All right. Oh, there you go. Strong versus weak marks. These are some marks I put up there that are considered very strong. I probably wouldn't recommend using any of those marks on anything, on any kind of product, even if it's dissimilar. And then you got examples of weak marks. You know, if your mark is beef burger, you know, that's a descriptive mark that's considered weak. Somebody else might, you know, they can use something with a similar name and probably get away with it. But those are considered weak marks. We've mentioned before, you get trademark rights by using the mark, by adopting it and using it in your business. That's all you have to do. You can register it. If you are relying on common law rights just through adoption and use, your rights extend through the territory where you've used the mark. So if you're using the mark in only a small area, you only have trademark rights in that area. If you register it, that gives you the rights throughout the entire country, even if your use is only in a smaller area. So that's the reason you would want to register. And David, you want to finish the list?
Just the last concept is all the ones we talked about, patents, trademarks, and copyrights, those all are publicly disclosed. So you've got to do that. There are some things where you may want to keep them a secret, and those are protected through trade secrets. There's basically three requirements. The information must be secret. Whoever owns it has to take reasonable steps to make sure it's secret. And you have to have some kind of value derived from keeping those a secret. If you have that, you may not want to publicly disclose that. And so those are circumstances when you want to keep something a trade secret. There's a new law that was passed in 2016, which now provides for federal cause of action if someone were to steal a trade secret, and which to do that. But just keep that in mind too. If it's something that there's no way, it's not possible for someone in the public to understand exactly, they can't get the information, then it may be best just to keep it a trade secret. The advantage of a trade secret is that it basically lasts forever. I mean, there is no term on it. As long as you keep it a secret, no one can figure it out. You got it. So that's just the last way to protect ideas. So that's kind of the end of our thing. Thanks. Any questions or anything? We'll be here afterwards. Thank you.
Great.